64, People versus Acevedo.
May it please the Court.
Counsel, would you like some rebuttal time, Counsel?
5 minutes, please.
Sure.
Your Honor. David Steinberg, representing the defendant appellant Stephen Acevedo. With the Court's permission, I would like to address the issue of appealability and then
Go ahead.
address the
Good.
The appellant's position, Your Honors, is that once a resentencing has occurred under the Drug Law Reform Act and a resentencing application has been granted and that the resentencing has occurred, there is a new judgment of conviction which triggers an appeal as of right to the appellate division and by permission to this Court on a question of law. Obviously.
So which provision of the CPL are you claiming we have statutory jurisdiction
I'm relying,
under?
Your Honor, on 450.30 subdivision 3, along with 450.10 subdivision 2 and 450.90. The reference to 450.30 sub 3 would be the fact that there is reference there to appeals from sentences and resentences if the original sentence has been vacated.
The 450.90 is the one that gives us jurisdiction.
Yes, Your Honor.
And it incorporates by reference those other two which relate to the appellate division's jurisdiction.
Yes, Your Honor. And clearly our position is that we do have, Mr. Acevedo did have a right to appeal, that his application for resentencing was granted, that the Second Department addressed the legal issue that was preserved, whether or not he was entitled to seek a concurrent sentence.
So that's what distinguishes it from Batista, where
Yes, Your Honor.
it wasn't granted, where the relief was denied?
The leave applications that have been granted by members of this Court were based on denials of resentencing rather than grants.
All right, here it was
of
granted.
resentencing. And here it was
And you have
granted.
the Mills case on your side.
We rely upon Mills' case on our side, and I would only
You're
submit.
also relying on kind of common sense that I assume that it's a resentence, so it's like a sentence and you can appeal it.
Yes, otherwise, the underlying issue here is a good example, in my opinion, of a question of law that needs to be decided, and it would be thwarted to have this Court review any questions of law, which obviously would eliminate the vast majority of the discretionary resentencings that have been granted, and it would eliminate that as a matter of common sense. We urge that this Court accept this case to address an important question of law because, quite frankly, we are approximately 5 years, going on 5 years into the drug law, the first of the drug law resentencing.
This is a discretionary resentencing. Why should we review it, since we usually don't review questions of discretion unless there's an abuse of discretion as a matter of law?
The county court in this case expressed the view in his decision that he lacked the authority to impose a concurrent sentence when the original sentencing court had imposed a consecutive sentence. And so, therefore, it set up this tension where a question of law would be presented.
Didn't he go a little further, though?
Yes.
What else did he say?
He also said that if it was up to him, he would exercise his discretion to deny this concurrent imposition. But he did say that he felt that to do so, to exercise that authority, in his words, would be exercising appellate authority over the original sentencing court.
You're just asking us to say that he was wrong in thinking he didn't have the authority and to let the lower courts worry about how they exercise it.
Yes, Your Honor. I think it wasn't clear cut. What Your Honor is referring to is obviously he also expressed the opinion quoted from the original sentencing minutes and indicated that he wasn't of a mind to exercise that authority even if he had it. I'm urging this Court obviously to address the question.
So let's say we addressed it. What do you want to tell us your view?
Yes. So the purpose of the now 3 drug law resentencing acts is to correct the harshness under various provisions of the sentencing law.
Well, wasn't the harshness, the limitations that it put on the original sentencing judge's discretion? Wasn't that the problem? That you could
Yes.
have that you might have a very, very sympathetic defendant before you, and you had to give him life imprisonment or some draconian sentence.
In this instance, Your Honor, my client was 21 years old when he was sentenced to the 15 years to life on the old.
Okay, but
No,
the Rockefeller drug laws, with all their harshness, didn't force Judge Marlowe to give your guy consecutive sentences.
That is
He
true.
did that because he thought
That
it was
is
the right thing to do. Why should he be entitled to a second look at that?
because I go back to the traditional notions that a sentencing, or in this instance, a resentencing court, ought to be able to control its own sentence. And I think there's a little confusion here that somehow we're arguing that we want...
Sentence relating to any other crime besides a drug crime?
In this instance...
Let's say it was a robbery and a drug.
Yes. And in this case, it was weapons.
Right.
But yes...
And do you argue that Murray supports that?
Yes. We argue that Murray supports it and that the second department in Vaughan, which was decided several weeks before they decided this case, and obviously felt it was controlling, they said that it technically, it may be a vacatur of the sentence, but there's an immediate resentence, and therefore Murray versus Gord doesn't apply. And I feel that's quite an overly restrictive interpretation of such an immediate...
But the jurist during the resentencing may not necessarily be the trial judge that heard all the testimony.
That's
and
true.
Was,
certainly.
And was well aware of...
We see
of what occurred. And in this case, the sentencing judge made it very clear that he didn't feel this was an individual that should have a concurrent sentence, correct? He said,
yes.
You know, you're not suffering from a drug addiction, you're in this business of selling drugs. He at least took the time and effort to put on the record why he felt this should be consecutive rather than concurrent.
That
so
is true.
why should we throw that all aside and allow judges doing resentencings to go back and second-guess those judgments?
It's an ameliorative provision in the different drug law resentencing acts now that allows for resentence to correct certain harshness here. And it's certainly, we should not tie the hands of the resentencing courts that are getting drug offenders back many times a decade or more later. In my case, the drug offender was returned to court approximately 8 years after he had been originally sentenced. And I don't think, I go back again to the tradition.
How is the weapon offense? I'm trying to understand the harshness argument with the weapon offense.
The original sentencing court made it consecutive to the 15 to life. And when I represented this young man at his resentencing, because I've represented him since county court, I asked the county court, to impose a concurrent sentence as to his own sentence, simply as to his own sentence, which would have had the effect to...
His own, you mean the second sentencing, Judge?
Second sentencing, the 15 to life that the judge, the 15-year determinant that he was proposing. I simply asked the court to consider imposing a concurrent, which would have made the other... Remember, Judge Marlowe imposed the weapons charges consecutive on the B felony drug sentences, the 12.5 to 25-year sentences. And we couldn't touch that. I just said make the 15-year A1 resentence concurrent, and
so as a matter of form, you're saying don't touch the gun sentence, just make this one concurrent to it.
Can't touch the gun sentence. It's simply we're asking the court to recognize the authority of a resentencing court as a...
So this is about, in your mind, judicial discretion?
Judicial flexibility, judicial discretion.
To get a just resolution, is that what you're, at least from the judge's perspective?
That's pretty far-reaching, though. We haven't permitted that in any other arenas, have we?
Well, I don't know.
Of resentencings?
Certainly, you allowed. Well, it is a resentencing. Murray was not a Murray was a resentencing in that the sentence was vacated, came back, he repled, and he was resentenced. I think it is very consistent with the provisions of the Drug Law Reform Acts, which seek to
Well, I
address
was
some of
just
the
going to
harm.
ask you, is there a particular statutory provision there that you feel
70.20
authorizes this?
70.25 subdivision 1,
Isn't that the last sentencing judge?
that's what Murray addresses. Yes, that the last sentencing judge certainly should have the say as to how he or she wishes to direct his or her own sentence. It's really that simple, it seems to me. My
Okay,
red light's
well,
up.
you'll have
Thank
your
you.
rebuttal. Counsel.
Thank you, Your Honor.
Counsel, why shouldn't it be the last sentencing judge?
Because, Judge, this is different from Murray v. Gourd.
How so?
This is a situation where all the legislature has authorized is an alteration of a drug sentence on an A1 felony. That's the only thing the legislature
He
authorized.
says they won't touch the other. He says he won't touch the weapons charge. There would just be that you're making the drug concurrent.
But you are touching the weapons charge if you're changing the consecutive and concurrent that was initially imposed. The only thing the legislature
So in real,
authorized...
your argument is in real terms you are.
You are, because the legislature only authorized an alteration of the drug sentence, and it was only the A1 drug sentence. We're talking about the 2004 Drug Reform Act, and the whole purpose there, if you look at how limited the relief that was authorized is, was only for A1 felonies, even though in that 2004 Drug Reform Act, the weights were doubled so that in this case, I think it was 4 ounces was an A1 felony at the time this defendant committed the act. After 2004, it had to be 8 ounces. The legislature didn't authorize, this defendant possessed, I think, 5 1/4 ounces. So under the new law, he would have only been liable for an A2 felony. The legislature did not authorize this to get dropped down to an A2 felony. They only authorized a very limited resentencing, and then it's an amended sentence, not a total. You didn't vacate the judgment of conviction as you did in Murray v.
Could they have made it
Ford.
ministerial then? I mean, why bring it back in front of a judge? Why not just say, on all A1 felonies, we're reducing the sentences from X to Y?
Judge Piggott, I know you read the decision, but I think Judge Hayes even mentioned the only reason we're bringing you back here now is because I told you we were bringing you back. But, yes, he was brought back. But I don't think it's not completely ministerial. But he knew before the original sentence was vacated, the judge was required to tell the defendant what he was going to sentence him to, and the defendant had the option of picking or not picking this sentence. He could take what he had, or he could take the new sentence that the judge proposed. So there's just a slight period of time there where you've got no sentence on this one particular drug case. And this is different. These types of...
Why isn't the slight period of time enough? I mean, if that's enough to make it a new sentence.
Judge, I don't think it is a new sentence, and I think the legislature recognized that it wasn't a new sentence because they made a specific provision in their statute as to authorizing the appeal from this particular amendment of the sentence or from a judge saying, no, I'm not going to offer you a denial. If this was a complete resentence, they wouldn't have had to have done that because it would have been covered by prior statutes.
What is your position on jurisdiction, by the way?
Judge, I don't think you have jurisdiction, and I think a very telling thing here is that the statute authorizes appeals to the appellate division. It makes no provision for appeals.
Suppose the statute had been completely silent on appealability. We'd have jurisdiction then, wouldn't we?
I don't think you would, Judge, because I don't think this is a resentencing. I think this is an amendment of a sentence. But even more telling, I think, is last year's bill. It's chapter, I didn't cite it in my brief, but it's chapter 56.
It's called a new sentence in the statute.
But if you look at chapter 56 of the drug laws of the laws of 2009, where you have the resentencing for Class B felonies, Section 45090 was actually amended to authorize this court to consider appeals from those resentencings. There's no similar statute that authorizes you to do that in A1 or A2 felonies. And I think it's interesting that the legislature, when they authorized you to hear resentencings from B felonies, didn't make any provisions for you to hear from A or
What about people
A2.
against Mills? We just missed the issue?
No, Your Honor, I think maybe part of the problem is that it wasn't brought up.
Well, everybody missed it, including us.
Well, I think it's the attorney's jobs to do that, and I recognize that. but I can't confer jurisdiction on you. I think that it's a constitutional and a statutory issue.
That aside, and I realize those are serious issues, what's the downside here? As Mr. Steinberg points out, if after a number of years someone who's been sentenced has shown themselves to have been rehabilitated or rehabilitating, et cetera, and the judge wants to recognize that in what is now in front of him or her, why shouldn't the judge be able to do that?
Well, Your Honor, I think there's a statutory provision that says once a defendant begins serving his sentence, if it's a lawful sentence, the court has no authority to vary that sentence unless it's specifically authorized by law. Here, the Drug Reform Act of 2004 authorized a change in the sentence, but only as to the A1 sentence. So I don't think the judge had the statutory authority to do that. And there's another issue here. In authorizing the resentencing under the drug law of 2004, the courts are authorized to look at how the defendant has behaved in prison. If there was no 2004 Drug Reform Act and somebody just came back to county court and said, hey, I've been a good guy in prison, please change my sentence, the judge has no authority to do it, and it's really unfair to everybody else who's sentenced who the legislature has not given some ameliorative treatment on a weapons charge or anything else. It's unfair to let these individuals, because they happen to have a bunch of charges as opposed to just one, to be able to have their whole sentence changed.
Would the original sentencing judge be able to make the resentence concurrent?
I don't think so, Your Honor. I think that if he had been a county court judge or a sitting trial judge at the time, he would have had the same limitations as Judge Hayes did at this resentencing. I think he might have had an advantage because he sat at the trial and he knew what the evidence was.
In fact, if he'd still been on the county court, this application would have been referred to him, correct?
Yes, Judge.
Is that significant in your view? Does that suggest does that suggest to you that the authors of the statute contemplated the judge doing on the resentence what he would have liked to do when but for the Rockefeller drug laws?
Well, Judge, first of all, I think that the answer to your question is Judge Marlowe had the authority to do whatever he wanted at the first
On the
sentencing.
consecutive, yeah,
I'm
asking you. I rarely do this, but I actually ask a friendly question.
Sorry.
I mean, well, yeah. I'm saying, doesn't that help you? That he was not constrained on consecutive sentencing back when and wasn't the point of the drug law reform to free the original sentencing judge, if he was available, or whoever succeeded him, of those constraints?
I think so, Your Honor, but I also think that when in the 2004 law, the legislature was concerned mainly with the nonviolent crimes, and this defendant really doesn't qualify as a nonviolent offender. He had a violent juvenile offender robbery to start out with, which is why he was only eligible.
The judge granted him a resentencing.
Oh, he certainly did, and he
And
gave
he was
him the
entitled to
minimum
do that. You're not
sentence,
quarreling
which
with
was
that.
15 years. He was serving a 15-year to life sentence on the A1 felony. The minimum sentence, which could have been imposed under the Drug Law Reform Act in view of this defendant's prior record, was 15 years with 5 years determinate. Judge Hayes imposed that minimum authorized sentence, but then he did basically, number one, he said, I can't change concurrent versus consecutive, but as Judge Piggott noted, he indicated that he would have imposed a consecutive sentence anyway, and Judge Marlowe had gone through his reasonings for that. I don't know if I've answered your question.
Okay, and I think you have. You're not suggesting, though, that comment by Judge Hayes makes this issue moot, are you?
Well, I think there's an issue of law and an issue of discretion. I recognize that.
But he says you decide the issue of law and let the other people worry about discretion. You agree with that, don't you?
That's correct.
Thank you.
Thank you very much.
Thank you. Counsel Roberta?
Very briefly.
Sure.
Counsel raises the statutory prohibitions under 430.10 about not changing, modifying, et cetera, but in the same breath also agrees that there has been an alteration of the sentence here. There has been a change, and so the introductory phrase, unless specifically authorized, I suggest, gives the resentencing court that authority to make the change. And I would also just underscore again, we never asked, as in Mills, the appellant did ask, that anything had to be shaped into an A2 sentence. This was in an A2 category under the new law. We simply asked that the A1 resentence be directed to be concurrent. It was approximately 5 1/4 ounces.
What's the net result to your client?
The net result right now is that he gained, it reduced the life sentence. It took the life sentence off of him.
Right.
But it didn't do.
But I mean, you want this this new sentence to run concurrent with
The net result shaves about 2 years, 2 to 3 years, because what it does, Your Honor, is it makes the 12.5 to 25-year sentences that are consecutive to the weapons the controlling sentences rather than the 15. The 15 would take the 5-year and it would subsume the 5-year. So the 12.5 to 25-year B felony sentences would be the controlling sentence, still consecutive with the 5 years, and that would be the net effect.
Okay?
Thank you very much.